So this morning at Thurston County Superior Court, the same judge, Judge Christine Schaller, who on Wednesday heard another challenge and a motion for a preliminary injunction to block the anti sheriff bill from taking effect, heard another lawsuit. The one on Wednesday was the one that was filed by the four Eastern Washington sheriffs who were challenging basically the First Amendment issues with the bill, preventing them from maybe posting something on social media or associating with someone that perhaps the Criminal Justice Training Commission could have an issue with. Well, on Wednesday, the judge agreed there are constitutional issues with the bill, and she granted that preliminary injunction on Senate Bill 5974 for the four sheriffs. The case today, and we were there as the arguments went down, was brought by Kitsap County Sheriff's candidate Rick Coos and another sheriff's candidate from Asotin County, along with the Washington State Sheriff's Association. And they were challenging specifically the new requirements of the bill for candidates that say you got to be 25 years old, you got to have 5 years of law enforcement experience uninterrupted, and some other things. Well, if that is allowed to remain in place, Rick Coos and the current undersheriff in Sutton County, who's running to replace the sheriff there who's retiring, wouldn't be able to run, even file their candidacy. Next week is the filing week. So there is a real sense of urgency here. So it was a fascinating hearing. Once again, Judge Schaller was very particular in going through the issues that she has with 5974, going through the Constitution and some of the requirements for candidates, and basically saying there isn't any other candidate for office, whether you're on the local level, county level, state level, in the state, that requires such a high burden that Senate Bill 5974 is requiring of elected sheriffs. Basically said the people have a right to vote in or remove an elected sheriff should they choose, but that shouldn't be something that lawmakers with this newly crafted bill are responsible for. So here is some of what Judge Christine Schaller said as she was handing down her decision today, granting a preliminary injunction in favor of the plaintiffs.
I find that the plaintiffs clearly have a well-grounded fear of immediate evasion of their rights. If the court were not to grant a preliminary injunction, these plaintiffs would be precluded from filing for office. You can only file your declaration of candidacy during 1 week. And this year it's May 4 through 8 of 2026, and they would be precluded. And that certainly is a well-grounded fear of an invasion of their rights. I also find that being foreclosed from filing a declaration of candidacy will result in actual and substantial injury because they would be unable to participate in the election. I think the state argued that it's not an actual and substantial injury because they might be able to run in 2030 because they could be eligible potentially at that point. I do not find that persuasive. I have weighed the criteria in light of equitable factors, including balancing the relative interests of the parties and the interests of the public. There is, as was argued by the state, a significant public interest in laws being constitutional, in laws being enforced. Because again, the voters voted and chose the legislators who create these laws. That's part of our system. But there is also a significant and strong interest for the plaintiffs, again, because their remedy is such a short window. They will be precluded from exercising a fundamental right to run for elected office, and in this case, the sheriff, if the court does not issue a preliminary injunction.
So, in today's arguments in favor of the plaintiffs, you had attorney Joel Ard, who was there sitting next to sheriff's candidate Rick Coos. And then from the state AG's office, we had Freeman Hawley. And he made the arguments that this should be upheld, that this is a duly, signed into law by the governor just a month ago. There's going to be a great harm to the citizens of Washington if this bill can't be fully implemented. It was just yesterday that the law went into effect, but again, only certain provisions of it. This again is a lawsuit that's very related, and at some point we thought the it might be combined, but ultimately they were not. So again, today she granted that injunction. So I spoke just after the ruling outside the courtroom with that Kitsap County Sheriff's candidate, Rick Coos, who should tell you, he's currently a King County Sheriff's deputy and has been since 2023 and had 20 plus years as a decorated Navy service member. But that would still not be enough under this law to allow him to file his candidacy next week. So here's what he had to say. And then next to him, Pierce County current sheriff, Keith Swank, who was there in the courtroom to witness today's arguments and the decision from the judge.
I didn't know what to expect going in because there was a hearing just a couple of days ago, and so knowing that this one was like completely separate, and just focusing on the qualifications and talking about how unconstitutional things are happening in Washington, especially with our legislators. And it just brings back the role of the sheriff being someone that stands up and fights against those unconstitutional laws and being there. And so just being a part of the team, I guess, per se, just standing up, fighting for the voters' rights, the people's rights to decide their sheriff. So huge win for the voters today.
And onward and upward with your candidacy.
Oh yeah, I'll be filing at 8 a.m. on Monday morning at the Kitsap County Auditor's Office.
This is important because first off, I'm supporting this gentleman here for running for Kitsap County Sheriff. I met him a few months ago, and I think he's going to be a great sheriff. And for the state legislature to pass legislation to preclude somebody for running for office is such an overreach. That whole 5974 is to go after people like me to keep us from being sheriffs, to keep him from being a sheriff, to remove us from office. And I'm really glad that this injunction was filed. I felt really good about it. But look, our fight's not over with yet, right? They can appeal it straight to the state Supreme Court, and I'm worried about that court and what their rulings might be. But this judge here, very honorable. She did a great job reviewing all the constitutional rights and provisions in this, and I'm really happy about it.
Now, at the same time these arguments were taking place, I received an email from Mike Falk in the Office of the Attorney General. He's their communications director, and he sent me their filing with the state Supreme Court. That was in response to the preliminary injunction granted on Wednesday in that separate lawsuit. Today, they asked the state Supreme Court to basically stay that order, and they want this to happen right away. We'll put up part of this for you. He wrote the court, or in the, I should say, the briefing that was filed with the state Supreme Court. It said this court should stay the Superior Court's indefensible order so the law can take effect. This relief is urgent because the new law regulates eligibility for the office of county sheriff, and the filing period for sheriff candidates is May 4th through 8th, next week. Without immediate action from this court, defendants will lose any fruits of their underlying appeal. So again, they're asking for a request, a ruling by Monday, May the 4th. So even with this preliminary injunction granted in both of these lawsuits, we could still have the state Supreme Court weighing in as soon as Monday. So stay tuned for all of that action.